This is Philip Bickle of Legal Tyranny, and in this series of videos we're going to go over a reply brief that I filed in response to the answering brief that the state of Hawaii filed in response to my opening brief. So this is the reply brief that I filed in the electronic certificate of service. Look at the table of contents. It's pretty much structured the same way as the opening brief. You have a statement of facts, your argument. We get straight into the points here. The appellee ignores well-established law, providing that it is the duty of a prosecuting officer, not an enforcement officer, to initiate criminal proceedings by the entering of charges against a defendant. Part B, appellee avoids acknowledging that the law specifically gives the duty and discretion of initiating a criminal proceeding to prosecuting officers, while excluding enforcement officers from the definition of prosecuting officer. Appellee attempts to explain away the failure to enter timely oral charges as being the fault of the appellant, although none of the reasons given fit under the Hawaii Revised Statutes, Section 701-1086. Now, that section right there gives you the only justifiable reasons for entering oral charges beyond the statute of limitations, and none of their excuses fit. We'll go over that. Part C, appellee avoids admitting that Judge Udovich scheduled a bench trial without any charges being entered or an arraignment held against the appellant. D, appellee fails to acknowledge and address Part E of the opening brief. G, appellee disingenuously reframed the reasons given for bias and prejudice by the appellant as various procedural actions the court judges took to which he objected. Appellee fails to address the intentional, knowing, and willful actions by the judges which deprived appellant of the right to fair hearings and proceedings before impartial judges. Now, that would include the instance of Judge Freitas completely ignoring me when I entered objections against him proceeding on January 4th, 2018, when he kept trying to allow the deputy prosecutor to enter oral charges months after the statute of limitations expired. So this is what they call that, though. Him ignoring me. Various procedural actions the court judges took to which he objected. Yeah, they're not allowed to ignore you. Okay, let me hit the conclusion. At this point, we're only about 4 minutes in. Alright, so some of these cases you'll recognize. They were already cited in the opening brief, and they just have to be reiterated here. Same thing with the statutes, going over the things that support my brief here. Okay, statement of the facts. Additional necessary facts for consideration of each issue appear in a reply addressing each issue. The record on appeal will be cited where appropriate. The transcripts of the proceedings for traffic criminal case noted hereafter as TR and by date. Section 2, the argument. Part A. Appellee ignores well-established law, providing that it is the duty of a prosecuting officer, not an enforcement officer, to initiate criminal proceedings by the entering of charges against a defendant. The appellee attempts to get around the fact that the prosecutors involved in this case failed to act timely by the entering of oral charges as required by the Hawaii Rules of Penal Procedure, Rules 5B, 1 and 2, and 7A, within the 1-year time period prescribed by the time limitations set in Hawaii Revised Statute 701-108F. In doing so, the appellee argues that criminal prosecution was commenced by an enforcement officer who, given a discretion, has opted to issue a written citation in lieu of committing the alleged offender into custodial arrest. See Hawaii Revised Statutes 883-6B. The issuing of a citation is not the initiation of a criminal prosecution. The latter is the sole duty of the prosecuting attorney. So, many of these cases were cited before. The appellee fails to address or rebut even one single instance of the cases that I cited in support of my argument that the prosecutor is required to enter oral charges within the time limitations provided in HRS 701-108F. The appellee fails to provide any evidence of charges being entered by a prosecuting officer within the statute of limitations that could constitute an initial pleading. The appellee fails to cite any controlling case law for the state of Hawaii supporting the position that the enforcement officer commences a criminal prosecution by the issuance of a citation and instead relies upon a tortured interpretation of the statutes for support. In my opening brief, I cited state statutes and numerous cases in which it was stated in no uncertain terms that the prosecutor holds the discretion to initiate criminal prosecutions by the entering of oral charges. I will reiterate this fact here. Since the prosecutor is generally charged with the responsibility of determining whether or not to instigate a formal proceeding, see Amemiya v. Sapienza, and that's a Hawaii Supreme Court decision. Many of you are going to recognize this citation. I'll go ahead and continue reading it, though. The public prosecutor has been delegated with the primary authority and responsibility for initiating and conducting criminal prosecutions within his county jurisdiction. The absence of the prosecutor's signature in a complaint, in our view, is not a mere formal defect. And in the Hawaii Supreme Court case State v. Solomon, clearly a police officer does not, nor is he authorized to perform the function of a prosecutor. Okay, so even in my reply, I'm including real short but extremely to the point citations that I already mentioned in my opening brief, but to make sure that the judges or their attendants that are reading these things actually pay attention to me, I reiterate these things. If they missed it the first time, they'll catch it the second. This court declared the following in the unpublished case, State v. Armitage. This is another winner. If you're not already subscribed, you want to subscribe because you're going to want to see this when I post it. This case applies to pretty much every situation in traffic courts across the U.S. You just have to find an equivalent case that says the same thing, and I guarantee you will. They all exist. So, State v. Armitage, and there's probably multiple like this one. I just happen to have this one through research, and then there are others that might not be as widely publicized, but the same issues were raised at an earlier point. This paragraph pretty much is the most important part of that, which is why I included it here. In the following traffic case, the state issued Armitage a citation which includes the applicable HRS section and name of each offense, but not the elements or essential facts constituting each offense. At arraignment, the state failed to orally recite the charge. Just before trial, Armitage waived an oral recitation of the charge. HRS, or Hawaii Rules of Penal Procedure, Rule 5B1 and 7A. Notwithstanding Armitage's waiver, because the state never apprised Armitage of the charge, the citation alone cannot within reason be construed to charge a crime. Okay, and again, this right here is happening across the nation. They're not entering oral charges. In my case, they didn't enter them within the statute of limitations, and they also didn't enter them without omitting legal terms. They didn't put it in the common vernacular. So, and they admit to this. They admit that they're relying on the citation, and the citation alone. That's what the prosecution is admitting. At least for the initiation of prosecution. Okay, so as the citation alone cannot be construed to charge a crime, and a prosecutor's delegated discretion as to whether or not a criminal proceeding will be initiated, the prosecution clearly failed to enter charges within the time prescribed by HRS 701-108F in a timely manner. At my first appearance on December 15, 2016, Prosecutor Evan Smith failed to enter oral charges, as the appellee tacitly admits, and the record shows that there were never any written charges entered by the prosecutor. And that's the transcript on this date and the record on appeal for my citation, so that they can see that that's a fact and it's supported in the evidence. The prosecutors failed to state an offense. The appellee admits that oral charges were entered on January 4, 2018. These oral charges entered on January 4, 2018 were insufficient, as I will explain later in this reply. This is 1 year after the statute of limitations, which expired on November 11, 2017. 1 year after the date noted on the citation issued by Officer Davies. So they've already admitted in their answer to certain facts that also support overturning the ruling by Judge Freitas. They're openly admitting they're relying solely on that filing the citation by the officer as their means of initiating a prosecution against me. But you can't do that. That's not permitted. Case law shows it. And that's it for now. We'll go on to part B in the next video. If you found this useful and interesting, subscribe, hit the thumbs up, and please share these videos with people. There's a lot of people that could start putting this stuff to use right away in courts if they just knew about it. So share the videos. Till next time.